Your Honor, first we'd like to start off by indicating to these families that we are sorry for their loss, that this is a tragedy. As the court's aware, Mr. Silver also has a family. He has a daughter, a mother, brothers, and he's a high school graduate. He graduated from Glenville, played football there. Your Honor, throughout this process, he has maintained his innocence. We would ask the court respectfully to appoint appellate counsel. We'd ask the court to order the transcript at the state's expense. We'd ask the court to recognize that he's been incarcerated now throughout this process and that he's indigent. We'd ask the court to suspend any court costs. Your Honor, in addition, we would ask the court respectfully to run these counts concurrent and to give an opportunity at parole. Parole would give an opportunity for him, while he's in prison, to have an incentive and hope moving forward. And that's definitely a consideration for the community and for this honorable court. Your Honor, in addition, we'd ask the court, as a matter of housekeeping, to note our objection to the Reagan-Tokes law. And thank you, Your Honor.
Thank you. Mr. Silver, anything you'd like to add?
Yes. I would like to start by addressing the surviving family members of the victims. From the top to the bottom of my heart, I sincerely send my condolences. I can't and I will not apologize for these charges and allegations. I'm not responsible for them. I did not kill those people or anyone else for that matter. But what I will apologize to you for is for everything you've all been through throughout this process. No parent should have to bury their child. I'm a father myself. I have an 8-year-old daughter. No family member and no friend should have to experience their loved ones being discovered in the state of decomposition that they were found in. I would also like to apologize for you all having to grieve this situation all over again. Due to the fact that old wounds had to be reopened, based on the fact that this prosecutor felt like he had the person responsible for these murders. Furthermore, he has a duty to get a conviction. None of this was about justice. I truly don't feel none of this is about justice due to the fact that I'm not responsible for these crimes. Furthermore, due to you having a duty to get a conviction, I'm all for that, but what about getting a conviction right? This is a perfect example to demonstrate to you all that this is not about justice. First and foremost, I did not commit any of these crimes. Second, we've heard under oath testimony that this prosecutor, Mr. Kevin Leandri, broke the law to secure conviction under revised code 2921.04 by harassing, threatening victims / witnesses, coercing and intimidating them to come testify. I quote, on telling somebody I don't even know who I'm telling on. This is a great big misrepresentation of our judicial system, more specifically according to the Ohio Rules of Professional Conduct, Rule 8.4.
Mr. Silver,
yes.
You're not an attorney, and
I don't need to be an attorney.
hold on. Here's the thing: you can make a statement, and
make
you
my
can
statement.
hold on, and you can also file an appeal. However, a subpoena that he enforced is a court order to appear, and a court order to appear, though the witness and yourself did not like the manner in which this person was brought to court, is within the bounds of the law.
So you're speaking for him?
No, what I'm saying is that is a court order. It is a court order for him to appear. So he's allowed to use the power of the police to go and pick up a witness pursuant to a court order. I'm not speaking for him. I am speaking for the power of the court of the subpoena, of the subpoena power of this court when, and the other thing is that your attorneys also have the power of subpoena, the same as the state does. And I explained this to you in your constitutional rights. If they had wanted a witness here, every defendant in this country has the same right to use the power of the court to issue subpoenas and use that same power to bring witnesses to court. So whether you did it or he did it, it's appropriate and it's proper to bring people to court so that justice can be done. And whatever that justice outcome is what it is based upon the evidence and the credibility of the witnesses. Go ahead.
You're done?
I am done.
So you do believe that we all have equal protection of the law?
I'm not answering your questions. I am
It's
listening.
constitutional, right?
I'm not answering your questions right now, sir. I'm listening to your impact statement, or your statement.
Okay. As I was stating, the Ohio Rules of Professional Conduct, Rule 8.4, prosecutors are advised and required to refrain from dishonesty, fraud, deceit, or misrepresentation pertaining to the rule or the overall judicial system itself. Sure, you can subpoena somebody to come to court, but texting and threatening them to come to court on something they should be willing to come tell, you shouldn't have to do it. You shouldn't have to do that. You shouldn't have to do that.
Mr. James, the witness that you're referring to, ended up crying on this stand.
Excuse me?
He was crying on this stand.
Who?
The witness that he had brought to court, had forced to bring to court. This person did not want to testify.
On
And
somebody he didn't know who he was testifying on.
he ended up telling it. However, he did it while he was crying. He was reluctant to do so. I can speculate as to why. Probably because he was in fear. But the credibility of the witnesses in this case, I can tell you, the jury found was profound. They deliberated for an hour and a half. The rest of the time it took them just to sign those jury verdicts. They believed the evidence in this case, and they asked themselves, do we believe the witnesses? And they went around and they said yes. Anybody listening to those two witnesses, in particular, I myself, because I also had to listen to the testimony for the court counts, those were credible witnesses, particularly Mr. Collins, who could not have known the level of detail less than 6 months after the murder, could not have been able to relay that level of detail that only the person committing the crime would have known. He would not have been able to deliver that to authorities without the person who had committed the crime knowing and being there. That is why the jury believed those witnesses. Anything else?
That's why they believe or you believe.
I also had to consider the counts. There was counts tried to the court, but that's what the jury relayed to me after this case. And I also had to consider the evidence in this case. And I was here and I sat next to these witnesses and I listened to them. And I'll just add on that Mr. Collins found what you had told him so depraved and such a burden on his conscience. First, he was scared for himself while in his cell, but one thing that he said to the effect of the reasons why he wanted to come and testify and why he gave that information was because he couldn't go on living knowing that the devil was out there. That's how he felt about this. And that's what he testified to. His motivations for coming here were purely to make sure that justice was done and to make sure that nobody else would be harmed by somebody who could commit such an action. Particularly, that was weighing on him, that as a coincidence, he knew one of the victims and wanted to make sure that justice was sought. And for this type of crime, with this many victims and this many bullets that were fired, how many times somebody had to pull the trigger? You had to pull the trigger. And then to cover up your crime, although I do believe that you weren't possibly expecting to see the other two women, but to leave no witness and knowing, being able to see that Ms. Lawson was visibly pregnant, and the testimony that she mentioned that she shouted that she was pregnant and you took her life anyway, weighed so heavily on this witness. And the jury found that the evidence matched up and the credibility of the witnesses only at the time, less than 6 months after the murder, the only person who could have been able to relay that type of information with that type of detail was the killer. And that killer was you. That is what the jury found, and that is what I'm sentencing on. Anything else before I impose sentence?
If I could respond to one thing, Judge, the defendant has filed a motion to dismiss. This court has read it. It's what he's been talking about. I'll just say this. I got that motion on Friday, and I immediately sent the entirety of all the text messages to his lawyers, and as you can see, they're not saying anything about them. There's nothing improper about any text message I sent to Reuben James or anybody else, and the record is out there. I think he's probably been reading from it here.
I don't have it.
Lawyers do. So that's it, Judge. Thank you.
Your Honor, we received that Sunday night, and that's going to be a decision and a judgment for another day. We're here to address this.
I think he's addressing it because your client brought it up.
Well, understood, but the manner in which he's addressing it is what I'm addressing, Your Honor, respectfully.
Okay.
I just want the record to be clear.
Yeah,
Thank you.
First, it's a pro se motion, and secondly, I hope I merited it. Right. So I have considered the facts in this case. I've also gone over your criminal record. Also, by coincidence, you were randomly assigned to this court. I had previously sentenced you to prison in 2 other cases. So I am familiar with your criminal history, which is essentially guns and drugs. I've considered the purposes and principles of sentencing. You had for street disrespect, you had hunted down and had to go through multiple abandoned houses to hunt down these 2 young men. And you did it in a manner and at a time when, and the evidence bears this out, that they would be unlikely to defend themselves, meaning that they were found in a state of undress, blankets over them, in possibly a time when they were sleeping. You carried out the executions of the 2 men, and when you saw the 2 women there, you decided, I'm not going to leave any witnesses. And even knowing that one visibly was pregnant and also pleaded with you, stating that she was pregnant, you decided to take both of their lives in order to hide your crime. You killed 4 people and an unborn baby. And the amount of shell casings that were found indicates the level of your resolve to make sure that they were dead and how many bullets were fired into their bodies. This is nothing short of a mass shooting. The sentence will be as follows. For counts 1, 3, 7, 9, and 10, for the aggravated murder of Dejan Willis, Christopher Monroe, Ayanna Quitman, Jasmine Lawson, and Jasmine Lawson's unborn, I'm ordering a sentence of life without the possibility of parole. For count 16, I'm aggravated burglary, 10 years in prison. Count 28, the attempted murder of Mr. Reuben James, that's 11 years in prison. For the having weapons under disability, as I previously stated, this is 2 additional times that you have used and had a gun. That's 36 months for each of those counts. For counts 1, 7, and 28, I am imposing the 54-month firearm specifications. Those will all run consecutive to one another. Except for count 16, all counts will run consecutive to one another. I am imposing consecutive sentences, finding that the consecutive prison terms are necessary to punish you and protect the public from future crime. You've already demonstrated through your criminal history that you live by the gun. You had had multiple gun-related convictions, including drug convictions, robbery, and protect the public from future crime. The consecutive sentences are not disproportionate to the seriousness of your conduct and to the danger that you pose to the public. And I'm specifically saying your conduct. I can tell you that the jury focused solely on the evidence in this case and the credibility of the witnesses. They were very good about separating the images that they saw and focusing on the evidence. And my sentence here today is based solely on your conduct. The fact that they were found 2 weeks later in that state, while horrendous, is not a factor in my sentence. I'm finding that that 2 or more of the offenses were part of 1 or more courses of conduct, and the harm caused is so great or unusual that no single prison term would adequately reflect the seriousness of the conduct. So you specifically went out and hunted these 2 young men. Then to cover up your crimes, you killed 2 young women, one of which was pregnant. And then when somebody tried to call the police to let them know that the person that they thought was responsible for this crime, you then shot at him in order to again escape any responsibility for this. And then lastly, your criminal history demonstrates that consecutive sentences are necessary to protect the public from future crime by you. The sentence then, adding that all up, the 13 years and 6 months of mandatory consecutive firearm specifications will be served prior and consecutive to 17 years to 22 and a half years on the underlying offenses, which is 30 years and 6 months to 36 years prior and consecutive to 5 terms of life without the possibility of parole. I'm going to go over because there's a life without the possibility of parole, I do not believe that I have to inform him of the SB 201. Is that accurate?
No objection.
Okay. The violent offender database.
No objection.
Okay, I'm going to skip that. Sir, you are ordered to be remanded. However, you will not be sent to Lorraine Correctional at this time because you do have another pending case that we do need to resolve. I'm going to explain to you your appellate rights. You have the right to an appeal of your case within 30 days after the filing of the court sentencing entry. If you are unable to pay for the costs of the transcript, the record, and all relevant documents required for the appeal, they would be provided to you without cost. If you are unable to pay for an appeal, you are entitled to have notice of an appeal filed without the payment of a filing fee. If you are unable to obtain counsel for an appeal, counsel will be appointed for you at no cost. Do you understand these rights?
Yes.
All right. I'm going to impose the court costs and fees. You have a very long time in prison with which you can pay them, and every single time that your commissary has its funds deducted to pay off these court costs and fees, you should be reminded of the harm that you caused and the expense and the ripple effect that your actions caused, not only for the family members but also of this community. So you are to be remanded. However, you'll stay here pending resolution of your second case. Anything else for the record?
No, Judge, thank you.
Your Honor, we would just ask the court to note our objection to the consecutive sentences We would ask the court respectfully to appoint appellate counsel and to order the transcript at the state's expense, and respectfully ask the court to reconsider the court cost as Mr. Silver is indigent. Thank you.
He does have the ability to pay. There's also the opportunity for work service, community work service within the prison. Your objections are noted for the record, and I will order a transcript at the state's expense as well as appoint appellate counsel.
Thank
Anything
you,
else?
Your Honor.
All right, thank you.
Thank you.